Importantly, the case assessed disability rights, not under ordinary legislation, but under the Constitution. This means that such rights protection can exist outside of a specific legislative framework on disability. The 2011 case, titled Electra Daniel, Administrator for the Estate of George Daniel versus the AG of TT, involved a physically disabled person who sued successfully for violation of his right to access to justice due to the fact that there was no wheelchair access to the courts of law. The Privy Council found a violation of his rights under Section 4 of the Constitution, which gives the right to liberty, security of person, and enjoyment of the right to property. The case raises important questions on how elastic general human rights principles can be in protecting persons with disabilities, and more importantly, to what extent positive duties are owed. Notably, Article 13 of the CRPD stipulates the obligation of the state to ensure effective access to justice. It is interesting that the Electra Daniel case was conceived of as a violation of access to justice rights, which gives a very broad platform, for example, with the potential to lead to access to other rights, including health rights or education rights and the like. The Electra Daniel case is therefore important because it increases the understanding of how general principles, even those emanating from ordinary international human rights norms, can be stretched to provide remedies for persons with disabilities. In conclusion, I want to discuss the need to implement the optional protocol. As we have noted, the CRPD envisions positive and proactive obligations placed on state parties to address several dimensions of disability rights. Trinidad and Tobago is only now awakening to the reality of this instrument that they have ratified. The need to act urgently is all the more important because of the relatively high numbers of disabilities that exist in our country. Even where some laws have been promulgated, they are seldom used or even known, thereby failing to either generate the culture of rights needed in the arena or even to offer concrete protection to persons with disabilities. In our view, disability rights can only be effectively realized if these issues are challenged directly before the courts, given the high rates of non-compliance with existing laws. An alternative route to enhancing domestic litigation is to bring disability issues before international bodies. On this point, we urge that Trinidad and Tobago adopt the optional protocol to the CRPD to permit its adjudicatory mechanisms to be released. The optional protocol is an option for individual complaints to be submitted to the CRPD committee by or on behalf of persons alleging that their rights have been violated under the CRPD. Through such international advocacy and remedies, the use of disability rights can be given prominence in the international arena and appropriate principles of law and policy promoted. There is an urgent need to develop and promulgate the jurisprudence in this area. With increased petitions, all stakeholders can be educated and sensitized about this issue, and we can make meaningful change so as to ensure that the rights of persons with disabilities are truly appreciated and respected. I thank you.
So our next speaker is Sunity Maharaj. As previously mentioned, she's the Managing Director of the Lloyd Best Institute of the West Indies. She's a career journalist of, shall I say it this time? Many years, and also runs her own multimedia production and consulting company. So, Ms. Sunity Maharaj.
Thank you very much. This is the second year I've been to this conference, and the thing that has always struck me, having been to many, many conferences at UE and other places, is the involvement of the audience. You go to a UE conference and people come to the opening and they go to lunch and they disappear, or they go to break and they disappear. The last time I remember, and I'm seeing the signs here, that what you have here is a very invested audience. Yes. I want to suggest to you that you have an invaluable connection to a community that you are actually creating through this conference. I also want to touch on your feature speaker, Paul, because I wasn't quite clear why Paul was doing the feature address, because I do not know Paul's other interests outside here. And I have really been struck, and I wonder if he was not born to marry his interests, because what you need is a voice, a communication capability, but what could be more special and important in your life than the championing of this work? So I make those because I want to, as a preface to my very short presentation here. In the introduction, the letter that was read from Rosemary referenced the apathy in the society towards rights. And I once wrote in a column, who needs rights when you have contact? Now that is the heart of the legacy of colonialism. That if you have contact, that means you're privileged. You don't need to fight for rights. You just pick up the phone or you just contact somebody else. So we go through the motions of going to parliament and establishing rights and so on, but nobody who is anybody of significance needs to believe it or to work for it. And so we have to ask the question, not simply to state that the apathy, but to question why. Because it is an understanding why and getting that accurately that you can build strategy that could make a difference. If you get the analysis wrong, if you diagnose it wrong, the prescription is going to be wrong, and you will spend money and time and energy and make no difference. So it's very important we understand the source of this apathy. And so the other point that has come out is how much of the research that informs policy is based in Trinidad. How many of the laws that we have to reference are based in the United States, Britain, and so on. So that immediately establishes, especially for the university and the community and the national community, a priority of work in terms of the work agenda for establishing the authority on which we will stand, the actual reality, the research that will identify very clearly in very precise ways what is the state. When we talk, for example, about facilities, we need an audit of all public buildings, all public offices, a human resource, a physical accommodation, and so on and so forth. We need, because you can't talk about quota, for example, which is maybe a direction you may want to go. I'm always struck by Shamla. You know, why is Shamla not employed and being the face of something to show the potential and the power, even by UWI? I mean, she had to work her way here to be able to get access to UWI. UWI should be proud to say, no, we don't want anybody employing Shamla. We want to employ herself because we want to make a statement. And also we want to demonstrate to others the potential and the power of this individual. And so this is the direction, but when we get to that, I wouldn't even need all that. When we get to, what I'm referring here is the informational basis on which a national lobby led by your community can be developed. And that requires solidarity. It requires, there are many organizations I know within the disabled community. There you've got the autistic, you've got the hearing, the deaf, and so on, and the cerebral palsy people with that. There are things that that separate you, and there may be differences between you, but I am sure there are commonalities and you have common interests. And so the things that, and this is something we could say about the whole country, put aside the things that are your differences and find a common ground on which you can stand and build a group that can become your public voice for advocacy. Our history is one of division, Our history is one of weakening communities through divide and rule. The most revolutionary action we can take in this part of the world is solidarity, because immediately one establishes the size of interest in the numbers, and of course, nothing without numbers moves politics. Right? And there is a sizable community, not only of people who are disabled or people who believe, but people, we who believe in rights. I do not have a right if you do not have a right. My rights exist as a community and as part of this population. And we need the expertise to join who are lawyers who will take your cases to the court. I have to say I have not been impressed by the Equal Opportunities Commission. I think it is far too bureaucratic. I think the Equal Opportunities Commission needs to be an advocacy unit, because one of the issues is for people who have come out of a history of no rights, we don't know what a right looks like. People assume we know what rights are. We do not know what discrimination feels like because it is normal. So we just think it is because the person don't like us or this and that. But when we stand on a clear understanding of what our right is, what we are entitled to, and what we must expect, and that is knowledge. That's about information. This is why I feel the task of the EOC really has to be significantly biased towards outreach. It has to be in your community. It has to be looking for the issues when you cannot even articulate them, to help you to articulate what exactly you are up against, and we will help you. And if the resource has to become the force that pushes with your support for more resources for fixing the legislative weaknesses, it cannot simply operate within that framework and think that that is good enough. So I think my time is up.
So, our next presenter is Mohammed-Davidson. She currently works at the Caribbean Court of Justice as a judicial research assistant to the Honorable Mr. Justice Rolston Nelson and Madam Justice Maureen Rajnath Lee. Ms. Davidson is also a part-time lecturer at Hugh Whitting Law School and here at the Faculty of Law at the University of the West Indies St. Augustine campus. Ms. Davidson obtained a Master in Law from Harvard Law School, where her studies centered on human rights law, constitutional law, and disability. Prior to her time at Harvard, she was employed at the Judiciary of Trinidad and Tobago, where she served as a judicial research assistant to the late Mr. Justice Kangaloo. Ms. Davidson obtained her Bachelor's of Law with first-class honors from the University of the West Indies, Cave Hill, and her legal education certificate with a certificate of merit from the Hugh Whitting Law School. She has a keen interest in contributing to the development of human rights law in the Caribbean, with particular emphasis on the rights of persons with disabilities.
Okay, thank you for that introduction, Veronica. I want to begin by expressing my sincere appreciation to both nodes and the Faculty of Law for organizing and facilitating this type of conference. With the ratification of the CRPD, which is what I will call it in line with what everyone else has said, we are on the cusp of a new and exciting era. However, in order to make the vision of the CRPD a reality in Trinidad and Tobago, it is necessary first to fully understand and appreciate all of its constituent elements. My aim today is to take you on a journey through the CRPD, examining its provisions against the backdrop of general principles of human rights law, and in particular through the prism of a principle of law known as 3 I's. Hence, the title of my presentation today is called The Ties That Bind, Analyzing the CRPD Through the Prism of the 3 I's. As we set out on this journey, however, a brief introduction to the concept of human rights seems to be an apt starting point. And this is to pick up upon what Ms. Maharaj would have said, that in Trinidad and Tobago, we really have a rights awareness approach. Human rights are rights which belong to all people at all times, in all situations, and in all societies. They originate as moral rights, as ethical claims that are made by all members of the human family. However, human rights have crossed a threshold into the legal dimension, and they are now recognized and protected in both domestic law and in international law. Our Constitution on the domestic level is the supreme law of this country, and it can legitimately be held out as the fountainhead of human rights law on the domestic level. However, all of our constitutions in the Commonwealth Caribbean have an international lineage, meaning that the bills of rights contained in those constitutions were inspired by international law. On the international plane, human rights law rose to prominence after the atrocities of the two world wars, in particular World War II. The first international human rights document is the Universal Declaration of Human Rights, which was adopted by the UN General Assembly on the 10th of December 1948. To underscore the importance of this momentous occasion, every year on December 10th, we celebrate Human Rights Day. And if it is anything that Caribbean people understand, is that if you have a holiday to celebrate something, then you know that it's important. The Universal Declaration, coupled with the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social, and Cultural Rights, create a sort of international Bill of Rights, for want of a better term. These rights are granted without discrimination on the basis of any kind: race, color, sex, language, religion, or other status. And it is this latter category that will provide for the rights of persons with disabilities. Now, in addition to the International Bill of Rights framework, we also have specialized human rights treaties, of which the CRPD is one. Taken at face value, there seems to be a dynamic tension between the International Bill of Rights framework and these specialized human rights treaties. And the question is this: if human rights belong to all people, if human rights are universal, if human rights are inalienable, then why do we need specialized human rights treaties to protect different categories of persons? This is where the principle of the 3 I's comes into play. The principle of the 3 I's attempts to rationalize